report against you in the case. So most probably the arbitral award gonna be also against you. So you need to look at this matter from early stage, even before you issue your notice of arbitration. You need to hire an expert. Let me say the word, but we will not stop a lot for this word. You need a dirty expert. And I mean the word exactly. You need a dirty expert. Okay? Why we call this dirty expert? Because he's gonna work with you, with your lawyer, to find out how to convert this case in your favor, how to find a gap, something that gonna be like a game changer to change completely the case for your favor. And for this, I will give an early example. In one of the projects, it is a pipeline. The employer, they put obligations on the contractor to check and review the design while it is design issued by the employer. They didn't complete the study of certain items, and the client discovered that the pipeline diameter, which is 400 millimeters, should be 800 millimeters. So not only this, also the pressure, it's not 16 bar, it is 40 bars. So they issued to the contractor very vague instructions to stop work, again to resume the work. They went to litigation later because they terminated the project because the contractor was not able to complete the project on time, for sure, because you have a cardinal change. We cannot say it's a change. When you change the diameter from 400 millimeters to 800 millimeters, the contractor lost everything. The materials of metal, the time he spent, everything. In the court of the first instance, he lost his case. When he went to the Court of Appeal, he hired a dirty expert. I don't like to say who is this dirty expert. It may be myself. Okay, so we studied the case, trying to find any solutions. It's no way. We found that the guy, he has in his contract 800 millimeters diameter. He cannot say that you change it from 400 to 800 because he has an item for 800 millimeters in his contract. Yes, the quantity is a small quantity, but they can increase it. Okay? But the issue in this case was that to play on the nominal pressure of the pipes, change it from 16, 25 to 40 bars. So we played on this very small technical issue. The expert was convinced. He issued the report in the favor of the contractor. Then the Court of Appeal ruled in the favor of the contractor. Honestly speaking, I was not convinced that this contractor should win this case. It seems that not only me who was not convinced. It is the justice of Allah. Suddenly, this contractor for the case, he didn't pay his subcontractors. So they filed against him a case for liquidation of the company. He was not aware of this case. He didn't attend the first instance. He didn't attend for the Court of Appeal. And the decision of the court became final decision for bankruptcy and liquidation of the company. Okay? So, why I told you this story? Because the word dirty expert does not mean this expert is doing dirty work, but they are saying it because of the mission itself. Because a word expert, the people are used to have this expert as neutral, as somebody who is working to assist the judge or to assist the arbitrator. They are not used to have an expert who is working hand by hand with the lawyer. The lawyer can work out and play with the words. But an expert, we are assuming that he will tell something like the judge. He will not be biased. He will be impartial. He will be giving everyone the balanced right. That's why we call the expert working with the lawyers as a dirty expert. Not that he is not a good expert. To the opposite. The experts who are working with the lawyers, in my opinion, should be more clever because they are facing very experienced experts in the courts, in arbitration, well-drafted reports, well prepared, highly qualified, highly experienced, and they need to attack this report.
Excuse me,
Yeah.
the expert cannot work with the lawyer because that is different job. He is, as we know, as per law, the expert is assist the judge or assist the arbitrator.
I can answer you. This is the normal what we know, but this is an expert witness. In Arabic, خبير محلف. In North Africa, okay, they use this word exactly, خبير محلف, okay? In Morocco, Tunisia, they use it خبير محلف. In the region, we call him appointed expert by the court. So, الخبير المكلف. الخبير or by the arbitral tribunal. But there is another kind of expert, and he is working legally correct because he is like an advisor to the lawyer. Okay, and this is normal, and this culture came from the common law. If you work in arbitration, international arbitration, it's famous, this technique of cross-examination, that you will find that, yes, there is an expert appointed by the arbitral tribunal, but you will find that the parties of dispute, every one of them, he is hiring an expert to assist the lawyer. And this is very important because many lawyers, they are losing their cases because they are not able to understand the technical part of the case. And when they receive the expert witness report, they cannot find out where are the mistakes. Yani let's take some items how I can even attack it. For example, I have an expert witness report, and this expert witness has no experience, for example, in delay analysis. Maybe he is good in all the engineering aspects, but he is not good in delay analysis. He does not have the experience in delay analysis. So he may be using a wrong methodology of delay analysis. The lawyer will not know. Is this wrong? Is this right? He will not know. He needs another expert to read the report and to challenge this expert witness. Especially construction, and it's more complicated in some other projects. Not only the construction is complicated. In construction, it's complicated, but even in some other areas, it's also complicated. Not only construction. I was thinking that it's only construction is complicated. But when I work it out in some other projects, construction is part of it. Not everything in the project is construction, like the PPP, public-private partnership projects, for example. So quickly, we need to differentiate between, we talked about the expert witness, and we talked about the factual witness. This is somebody, factual witness, he will come to tell us, I saw, I noticed, I watched. He will tell us about an event happened, and he witnessed it. If I find something like this in the expert witness report, I have to attack it, because I hired the expert witness for his experience. I didn't hire him to come to tell me, I noticed, I watched, I attest. If he put anything of those, he is not in this column, he came to this column. So at this point of time, I have to automatically, in cross-examination, I have to be seeking such words. If I find that the expert is not telling his opinion, his calculations, with justification coming from where? If I will find him writing in the report, this party says, this party provided, this party advised, the other party responded, the other, I am not having an investigator. I hired the expert for his experience, for his long experience. So this is also part of the difference between two types of witness. The second thing is, we said that why we have to go to cross-examination, okay? One part also for this cross-examination is that sometimes we find that the expert is impartial. And he is not impartial, and he is biased to one of the parties. He is on the side of one of the parties. You can read some reports. I recall an arbitration case, and we were lucky that we annulled this arbitral award. It was a dispute between an investor, developer, and the contractor. And the arbiter tribunal, they appointed an expert witness from the nationality of the investor. The investor was foreign investor, okay? And I was wondering, why the contractor accepted this? Why he didn't challenge this? Because there will be certain he will be biased, okay? The surprise was what? The arbitral tribunal, they were convinced with the expert report because the contractor didn't challenge it, didn't hire the dirty expert. And they passed the mission outlined to them from the tribunal, and even the tribunal in their award, they said yes, because the lawyer, he challenged that the expert gave a judgment. He didn't give an opinion. He ruled on the case, and the arbitration tribunal, they accepted it, and they said that, yes, we recognize that the expert went beyond its mission, but it is welcomed. I will say it as they wrote it in Arabic. They said, وإن كان الخبير قد تعدى المهمة الموكل بها إلا أنه اجتهاد محمود. And I have this arbitral award it's 80 pages because I was in this case. So اجتهاد محمود. So we took this sentence and we challenged the arbitral award in the court, and it was annulled. So this is to provide you how it is very important, the role of our friend, the dirty expert, who is doing the cross-examination. Cross-examination, in most of the cases, it is done by lawyers, but some good lawyers, they play the game like this. He said, if I go and do the cross-examination, I will not be able to attack this guy. He's gonna talk to me technical. So he is hiring this dirty expert to support him in this cross-examination. How cross-examination is coming in litigation, despite that you don't have this in litigation. And we are leaving this in practical cases. Once we are submitting our expert witness report, and it's not in favor of one of the parties, the party who has the report in his favor, he is directly accepting, okay, the report, approving it through the portal, we call it Khibra portal. Automatically, he is accepting it. The other party.
But the worst part is they have chance to object about.
They can object, but what is happening in practical? In practical, the first party, he finds that the report in my favor, so automatically on Khibra portal is accepting, approved. The other party should challenge. His lawyer cannot challenge what they are doing. They are hiring another engineering office to prepare, because here still in litigation, little bit this cross-examination technique is not well developed, is still not yet matured like common law jurisdiction. So they are hiring an engineering firm to provide another report on the dispute. And they are submitting it as a challenge to the expert, as they are saying, okay, those are our comments. So, and like this, the experts need to answer the other expert in writing. This is what they are doing, okay? The final decision is the expert who is appointed by the court. But the game here is that as an appointed expert by the court, you cannot ignore the other expert report, because this is in the first instance. For example, if they go for the court of appeal gonna call you, because some experts, they thought that, okay, I don't care, I will disregard this report, I will not answer any of what allegations he is saying, okay, no problem. But the Court of Appeals, they have the right to call the expert appointed by the first instance court to ask him, why is this point like this? Why you didn't take into consideration this report? Where is your answer for this one? Something like this. They have this right. And they are very clever. And judges, in my opinion, in many cases, despite that I'm not a judge, I'm an arbitrator, in many cases, judges are doing great effort, even if they are not for construction disputes, they are not engineers. If they don't come to be convinced with the expert witness report, they are calling the expert witness to the court, not even to the hearing. They are calling him individually to the court to sit with them, and they start to ask him, to explain to them from where you came to this point. Show us the calculations. Explain to us. If they became convinced, okay, they accept the report. If they don't become convinced, they gonna completely reject the report. So this is also happening without the need of cross-examination, but you as a contractor, as a party in the dispute, if you are ready to let your case to be dealt with like this, okay, I will let it, the arbitrator will do the necessary. But suppose the arbitrator is convinced, he will not call the expert, he will not ask him any question. Even the judge, if he is convinced, he will approve the report, he will not ask any question. So you have to defend your case, you have to defend your rights. No one will defend it to you. So, very important to know when to go for cross-examination, because sometimes if you do the cross-examination in wrong way, you are making the arbitrator, and even with the way we said the methods that the people are using under the litigation to play around and to create cross-examination between brackets, so you will get the arbitrator more convinced with the report. If you don't play it correctly in cross-examination, you are playing to the interest of the other party, not in your interest. So you need to know when, okay, to go for this cross-examination when you are sure that you can find gaps, anomalies, you can find inconsistency, you can prove that the expert is biased, you can find that he didn't rely on opinion or calculation, he relied on certain facts, okay? He converted to be a factual expert. So here also, and this is good to know, when I should not ask for cross-examination, we talked about it already. Okay, so I have to define what is the scope I need from the cross-examination. Okay, and by the way, as I told you now, cross-examination may be against the party who is doing it, but if I am a clever lawyer, if even the report is in my favor, I can ask for cross-examination. And I can go for cross-examination to help the expert to support his opinion. And we did it. In many cases, we did it like this. Okay? Even the report in our favor, but we found that there are some gaps, some weakness in the report. The other party can attack in his comments or challenge. So we issued a report that is confirming the expert witness report, but we gave more explanation, more justification, so the expert, when he will be attacked by the other party, he's gonna use our report. So this is how the game is played even in the court. Okay, so here, can I say that this is a dirty expert? Already the report in my favor, but I'm trying to strengthen the expert witness report, which is issued in my favor, simply. Okay, go to the famous question in every profession we have. Is it an art or it's a science? Okay? In my opinion, it is mixed between both, but it's a gift from Allah for the person who is doing the profession. Every one of us is doing a profession, okay? And he is clever in something. Allah subhanahu wa ta'ala, he gave him certain specific skills to be clever in this area. And every one of us should discover, I am clever in what? Then I have to develop it. So you cannot bring somebody who has not the skills, who is not created to be a dirty expert or even to be an expert witness, to create from him a good expert witness. First, he should have, like, he is ready to be expert witness. He is ambitious of doing it. He is looking to do it. He loves it. If he does not love what he is doing, he will not be creative. So creativity in even providing the expert witness and the cross-examination in expert witness, this is creativity. Because 10 experts may read the same report and they may say, yes, the expert witness report is correct. One dirty expert witness can come to say, I disagree with the 10 experts. I found a gap here, an anomaly here. I'm going to attack this report. I'm going to prove to the court or to the arbitral tribunal that this report is incorrect. And he will do it. So at this stage, I cannot say that it is only science, because all they have studied the same, all they have the same knowledge, but only one between 10, he said that I'm going to attack it. I found the way to attack it. It's like lawyers. We have some lawyers who are, for example, well known by the name. Yani, for example, I can give an example right now. You may listen before about Farid al-Dib in Egypt. He's a famous lawyer. He is famous than even the deans of faculty of law. Okay, he is famous than them because this guy, rahmatullah alayh, he was created to be a lawyer like this, with this mentality, with trying to find it, where is the gap. Okay, we know now Ashraf Nabil is now, he's taking his place. Okay, so we have a risk in cross-examination. It's not something that we can go and we will get it easily. Many risks are there. As I said, sometimes it's better not to go for cross-examination. Sometimes it's not in your favor. Sometimes we call it let it go. Okay, you have to resolve it away from the expert witness. So we have to attack, we said yes, the credibility. So we need sometimes to push the court or the tribunal to cancel and annul the mission of the expert. And we can play on this, but sometimes, especially in arbitration, they challenged you if you have selected this expert. So you have to be careful when you are selecting it. Sometimes they are telling you, yes, but you have selected him. How you are coming to attack him right now? And this is in some awards, it's like this. They are not accepting that you go for this. So anyhow, from early stage, you can start to play for.
Only the point that you have mentioned right now.
They're going to challenge you.
Yeah.
If you select the expert, some arbitrators are challenging you. They are saying, you selected him, you proposed him.
I selected him based on technicality, and that's because he just want him to.
This is the point. So if you selected him, you cannot go and tell them he is not qualified technically.
It's not a matter of qualification. It's a matter of that is something is missed. Just I'm going to just to compensate something just missed by him.
So if you
You're going to attack him in his
yes,
problem.
you attack. Okay, I agree with you. If you attack him for any point other than his qualification, his experience, they're gonna listen to you. But if you attack him for his experience, for his qualification, while you selected him, they will not listen to you.
Actually, with due respect to the court and with due respect to the expert himself, I'm not going to attack him in his person or his qualification, because he's already selected by the court. I have to respect the court. I have to respect the tribunal at the same time. In this case, I'm going to just to attack the report that he provided on the before the court.
I will give you a real case happened with us. Okay, in one of the cases, we found two different expert witness appointed by the court, by the tribunal. Okay, they have been appointed the same day. They appointed two different experts, and we were hired to attack the two expert witnesses' reports. And the two experts, they gave, this is what the tribunal did. They played the game what? They took the parties' approval to appoint two different expert witnesses. They issued to them the appointment letter the same day with the same requirements, with everything. When they received the reports, there was contradiction between both. Okay, this was the complication, and the other parties, they hired us to come, guys. We need to attack both reports. We found that we cannot attack both reports because the tribunals, they will not be convinced. I have two different opinions. How you are coming in cross-examination to tell me both experts are wrong, we are right? So we tried to take the side of one of them, which is the most closer to our position. And we strengthened his position to get out from this one. So quickly, if you, here we are talking in general concept of taking the witness and investigation of his statement. And this also applicable to the expert witness. So let's see, in expert witness, how I will do. I have to be very calm. I have to attract the tribunal with me. They feel that I'm correct. So I have to be very calm. I have to ask the expert in a very slow tone. I should not challenge him. I have to challenge what is written in his report. So I have to avoid to take it personally. Otherwise, the tribunal will not be convinced. They're going to say that it's a personal issue between them. It's not something that is related to our case. So this is the key thing. The second point, I have to give him the ground to answer. But I cannot leave to him the full ground. I have to tell him guided questions. So he cannot escape. Because you are asking a very experienced guy. This is his life. He is an expert. When you are asking him a question, he can play around and you will not catch him. So you need to get very well preparation before you go for this cross-examination. You need to study the case well, and if it's not part of your experience as, a dirty expert, don't do it. You need to find somebody else. The questions should be clear, very clear, because you are not only asking the question to the experts. Arbitrators are there, maybe they are not engineers. And until today, I know that there is an amendment is undergoing, still not yet issued, for the Saudi law of arbitration, and this is one of the advantage, in my opinion, until now, very good advantage, that if the tribunal are composed of 3 arbitrators, one of them should be a lawyer. Still, yes, the law is like this now, but I think there is a modification published still to take the opinion of the public on it. There is this change. The condition of having the one lawyer between the 3 is no longer, and the condition for if you are getting a single arbitrator should be a lawyer, also this may be removed. This may be removed. Because this may be removed because this is, I think this is modification are there. It's still not yet issued, but it's on the website which is called I don't recall the name of the website, but this website is they are issuing the new laws on it to take the opinion of the practitioners and all of this. Istitla, yes. This is, yes. So on Istitla, you will find a project to some modifications in the arbitration law. You will find this condition. I found it, it's not there. The legal qualification, okay? So this is also, we don't like to take nice, okay? So quickly, I'm gonna summarize to you what we should do. So we need to ask a guided question, and we only ask a question that we know the answer to. And this is important. Don't ask the expert a question while you don't know the answer, because you are going to challenge him. How you are going to challenge him and you are asking him a question that you don't know the answer? You should know the answer. So if he is telling a wrong answer, you're gonna challenge him. So question we said very simple, and don't ask or to repeat his what he said in the report. Okay. Anyhow, and also don't argue with him, and this is very important. You know, don't need to argue, but you can prove that he is not correct, he is not right. But if you start to argue, it's not in your favor, because if you have a well-developed challenge, you will not argue. You will be telling him, look, this is your book. You published a book, you said an opinion against what you are writing in this report. You killed him. You can take, for example, for him, a recording from a lecture he delivered. He said an opinion opposite to this opinion. An article in the journal, newspaper. So you can, this is killing the expert witness report, because you have written evidence that he is not saying his well-known opinion in the matter. Okay, so I think we talked about the difference between common law and civil law. Common law is well known there, the cross-examination, while in civil law it's not well known, especially for certain countries. And here in Saudi, the expert witness is appointed by the court by a well-developed procedure. You can go and select and do all of this. In some countries, for example, the expert witness are department from the Ministry of Justice. They are employees. So sometimes you don't have even the opportunity to choose. So you are not choosing who is the expert. Okay, so now if you will be in charge one day to play the role of dirty expert, so you need to be well prepared. Prepare your team, prepare the case, get the right expert with you, get the questions well developed, use the techniques, okay? So this is the most important things. I think now we almost reached to the objective of this quick overview on the cross-examination. And I again extend my thanks to Dr. Nabil for the invitation for this event, and thanks you for attending and listening. Thank you.
Can we take some questions?
Yes, for sure, Doctor.
Anybody have any questions?
Yes, I have one question.
Yes.
Leading question and directed or
Leading a question, I will tell you how I can ask leading a question.
There is on
The answer for leading a question gonna be yes or no. He cannot find some escape. Okay? Like when I tell him, Mr. Expert, you in your report, you stated that a concrete mix for this project should have been with 400 kilograms. Didn't you? He will say yes or no. Or I can create also same question, but for another fact or technique he didn't use in his report. Mr. Expert, we know that the delay analysis, retrospective delay analysis, is not to be used during the project period. This is what is stated in the American Association for Cost Engineers protocol. The RP 29. Is this correct? He should say yes or no. So this is a guided question. I'm not leaving to him anyway to skip, to play with me, because he is more experienced than you. You need to put him on the track.
You can answer, I don't know.
If he answered, I don't know, he gonna lose the case, because like this, I will be successful in proving that the expert witness lost the credibility. So I win it, okay?
Also, you can use the technique of, do you agree with me?
This is I don't like to use me myself. I have, because if I open to him, do you agree with me? This means that I'm giving to him an open question to give his opinion. But when I tell him a question, he should answer yes or no. It's not an opinion.
Discuss, do you agree? He's going to agree or disagree?
No, you are saying agree with me. This is very important. Every single word is important. If you say agree with me, this means that who are you?
No, agree with me on the fact.
On the fact. So it's better to say yes or no. Because opening the door to agree, this means that you are asking his opinion. No, I'm not asking your opinion as expert here. You used a protocol of American Association for Cost Engineers, and it's written in this protocol that you are not to use this method during the project. It's expressly stated.
We use it in the law, that's what
Yeah.
lawyer.
Yeah.
Do you agree with me? It's normal to use
Yeah.
it. You agree with me, it's normal to use
Yeah,
it in the law.
yeah. But we give the question to our colleague.
Oh, thank you very much for the insights. My name is Shadi Atin. I just think that it could be important in this context to highlight that most experienced experts and tribunal members are familiar with the technique of using leading questions. And in most of the cases, in my experience, that the expert is always permitted to say yes because or no and explain himself. And if he's interrupted by the counsel by insisting of saying, sir, I just wanted to hear your answer in short, yes or no, I have very limited time, and so on, then the tribunal would, in most of the cases, allow the expert to explain himself. And of course, this doesn't mean that I disagree that we should prepare ourselves for leading questions when we are cross-examining. But also, we need to be prepared that if the expert is going to take the chance, how we can and what technique we can use so we can put a limit and in some circumstances to his answer. And one final point, it's also important to highlight that leading questions are not permitted in the redirect. So if you're redirecting your witness, then you are not going to be allowed to use leading questions.
But here I have a point here that he is not a witness of fact. He is an expert witness here. So redirecting him, I'm not redirecting an expert, a subject matter expert in his matter. He is the subject matter expert. I'm not redirecting him.
Redirect after following the prosecution.
Yeah, so I'm not redirecting at all. I'm not. I am not redirecting him because, let me explain it to you. Because when you answered, you said that he's gonna say yes because, no because. In my opinion, he started with yes or no. I don't care after what he gonna say, yes or no. My focus is on the yes or no and then I gonna develop this on the yes or no. If he said yes, and this was the answer that I am looking for, 90%, what he gonna say after yes, it's in my favor, because yes was in my favor. But if he gonna say no, and no is not in my favor, he also answered the guided question. He answered it with yes or no. Then I gonna challenge the reasoning he is giving. Okay, this is what I gonna do as a dirty expert. I gonna challenge the reasoning. I gonna tell him, okay, but there is another theory, or there is another issue, and this theory is not proven. Yani, for example, if you go to Australia, for example, they ruled on the American Association of Cost Engineers protocol in several cases. They said, no, you cannot use. Okay? They ruled on other cases on the SCL, Society, Construction Society law. So they ruled on it. It's not the best one to be used in those cases, you know. So you will find a way, in my opinion. And if you have a clever, dirty expert, okay, he will find the way before he go and face this expert, and he will use like a pyramid of questions. He should start with very specific question. If he hits the question and finished from the first one, thanks. If he is not finishing from the first one, he should be prepared with the second question. Okay, if I didn't get this expert from the first question, what's the second question I should do? And he should be well developed to make it, you know, like you are building the pyramid, as we can say. Okay, until you reach to the point, you reach to your target, finished. This is what I'm doing myself. Okay, may not be in some opinions not the best practice, but you don't have another way, because you need to attack it to kill the credibility. You have to find a way. Okay, I hope that I answered your question.
Yeah, thank you very much.
Okay.
I mean, that's a very open topic, and we can
Yeah.
keep going on. I don't want to take the time.
Yeah.
Thank you very much.
Thanks. Thank you. Okay, Doctor, thank you.